Good morning, everyone. Today is Tuesday, September 15th. I am here today with Jackie Durham, my dutiful law partner. You'll note the absence of Marina Parkin given the calendar date and the extension filing deadline for tax returns. Marina is under a big tax rock, so she won't be with us today. But what we have for you today is a very interesting topic in terms of both the law and accounting side. So there's so much to talk about here that we actually wanted to break it up into two segments. So today we're going to be talking about the ins and outs of purchasing a business from a legal standpoint. And then part two will be incorporating from the tax standpoint, what you should be doing with your accountant, due diligence, et cetera, prior to buying or selling any business. So without further ado, we will jump right in because we've got quite a bit of content today. As always, please feel free to enter your questions down in the bottom at the Q&A box so that we can make sure that we're responding to you as we go as well. So Jack, tell us your latest disaster du jour.
Yeah. Oh my gosh, there's so much to go around. So I think that, I kind of wanted to just go through sort of the flow of how the whole business transaction goes from start to finish. This is going to be more high level, like Joanne mentioned, so I'm not going to get into a lot of detail, but we might even have a third part to this webinar where we go into a little more detail, especially with the contract, because I feel like there's a lot that we could get into on that end. But just to start, I think when you're looking to acquire a business, the first consideration that needs to be made, which probably should be a discussion with your attorney and your CPA, is going to be whether you're acquiring the assets of the business, which is just going to be the tangible assets like the tables and chairs, along with the business name, the the trade name that it operates under, logos, things like that. Or you can acquire a business by purchasing the stock or membership interest of the operating entity. Now, we typically recommend an acquisition of the assets if it's possible. Mm-hmm. Sometimes it's not practical because of certain licensing requirements or things like that. Sometimes the purchase of the stock is just necessary for that reason. But from a general standpoint, there's a lot less liability that a buyer assumes by acquiring just the assets of the business. So from a general standpoint, now there's some exceptions that I'll get to later in the webinar, but from a general standpoint, when a buyer is purchasing the assets, they're not assuming the liability of the seller for the prior operation of the business. However, if you're acquiring the stock or the membership interest, mm-hmm. you are basically stepping into the shoes of the seller, and you will be assuming some of that liability. Now, there is going to be contractual provisions that typically will protect you, like an indemnification provision, but enforcing those provisions is not fast or cheap or easy. Mm-hmm. Exactly. Mm-hmm. So you're taking on more by buying the stock or the membership interest. So it's really recommended that if you can buy the assets, you go that route. So that's the first consideration I would make, right, Joanne?
Absolutely. And let me also say that the public, the outside, won't even realize, they won't know either way which option you chose. There will be continuity. Like Jackie said, you're not only buying the name, you're buying the website, you're buying the phone number. So when people call, Sam's Diner, they're still going to believe this is the same business. And I don't mean that to sound like you're tricking them, but they won't know you're going to have access to that name. So the public is not going to be aware even that there was a change in ownership necessarily. Sometimes that's a good thing. Sometimes you want them to know it's under new management, particularly in the restaurant industry. But right. That's just some other consideration, is that this is all internal. So whichever route you choose, the public's not going to know. Typically, if we see folks going for a stock purchase, like Jackie said, there's either licensure or insurance. We see it a lot with like medical supply companies, where if you take insurance, or particularly Medicare, it's almost a year to get registered with them. So we'll see it too in physician practices or ancillary medical services where insurance or Medicare are accepted, because to be recognized through Medicare is nearly a year-long process. We've also seen it with certain state licensing, that the process would put you out of business during the transition period. So,
right, exactly. Those are some considerations that need to be made, of course, in advance. I would recommend definitely talking to a professional about which option you go with there.
Jackie, how many times when you get a contract in the office and you talk to the potential buyer, the prospective buyer, do they even understand if they're buying assets or stock?
Oh my gosh. Well, half the time they think they're buying stock when they're buying assets and vice versa.
Yeah.
So, a lot of times if you are dealing with an agent, the agent will put together the offer for you. And they aren't a legal professional. They can't legally explain to you the way that works. So that's even more reason why it's so important to work with an attorney when you're going into something like this. And I do think that agents serve their purpose, and that was actually going to be the next thing that I touched on is, should I or should I not use an agent? And as a buyer, I feel like it totally makes sense to use an agent. Number one, because especially if this is a new kind of business for you and you haven't done a lot of business purchases in the past, or this is a completely new industry to you, you really need somebody to guide you through that process. And I think that agents can be extremely helpful in that regard. Another item to consider is the fact that typically the seller pays the agent's fees out of their proceeds. So really it's a win-win for you. You typically would not have to come out of pocket because the seller typically customarily covers that cost. And agents can be invaluable and holding deals together and working through certain things that practically you don't want to pay an attorney to work through because it would become, it would not be cost effective. So I highly recommend using an agent for those reasons. And even more important is making sure that the transaction is actually closed by an attorney. Whether or not the parties actually have attorneys representing them, you may say, hey, I don't want an attorney to represent me. I feel comfortable working with my agent on this. At the very least, you want to make sure that a licensed Florida attorney is closing the transaction, because that attorney will ensure that the transaction is closing in accordance with the contract and also in accordance with Florida law. So what I've noticed, and what is alarming sometimes, is how often parties will transfer stock or membership interest between themselves without the assistance of an attorney, or will transfer assets without the assistance of an attorney. And many times they ultimately realize after the fact, many times when they go to sell the business, that it was not done properly. And now they have to go back, repaper that, basically redo the transaction all over again, because they don't actually hold legal title to the assets or to the stock or membership interest. So you want to make sure that you do it right the first time, because it can cost you the business later, and it can also result in residual claims coming to you from the prior owner.
Not to mention if something happens in the meantime, like you thought you bought a car and you didn't, or delivery truck or whatever, and you didn't actually acquire legal title. Now there's a car accident. Now there's some liability, and you thought you sold it, same thing. Now you're not insuring it because you don't own it, except you still do. And all kinds of problems come from that. And it could be small things or big things.
Yeah, exactly. It could be a lot of those things. And I'm shocked at how many times we dive in and look into the titling of things and realize that these assets are not actually titled in the name of the seller. They're titled in someone else's name.
Yeah.
So
who's this guy?
yeah, it happens more often than people think. And it's just, that's why it's that much more important to make sure that you have an attorney at the very least closing the transaction. So the next item I kind of want to jump into is the purchase agreement, which is really the Bible of the transaction. I'm not going to dive into as much detail as I would like to. We could have a whole hour just talking about these different provisions, but I am going to talk about some of the main players that appear in these purchase agreements, or that at least should appear in these purchase agreements. And, kind of just touch on these, and we'll go into a little more detail in another webinar. Do you have anything to add before I dive into that, Joanne?
The only thing that I would say as well, as before you jump off of that, is people have a tendency to feel when they get to us, typically from a business broker, that they, you have a choice whether we represent one side or the other, or we serve as a transaction only closing agent, meaning we don't give advice to either party. We just make sure that clear title changes hands. People erroneously believe that transaction only is going to be less expensive. I would say that in my experience, sometimes the opposite is true, and sometimes it's more expensive because it's more cumbersome for us because we don't have a client. So we've got to be neutral to everybody. We've got to bat back questions that we can't answer. You basically take us off your side as a lawyer and put us in the middle, which is fine, especially if there maybe is a key man who's taking over the business, who's already familiar with it. It's not a third party off the street. There's already a relationship. You already trust each other. But for a third party transaction, it really, I think people choose that and then later on are disappointed when something comes up. And I don't mean that there's like necessarily even a problem, but they're looking for some advice, and then we have to put our hands up and say, I can't answer that for you. I'm not your lawyer. I'm just the closing agent. Now, what are you going to do? Try to go find another lawyer to get in the middle of, it's just very messy. So it does happen with some frequency, but I would just suggest that it's maybe not the lesser expensive way to approach it.
Right. And what I will also say is it's unfortunate in those circumstances because the contract is brought to us, signed, and we play no part in reviewing or making recommendations. So I'm seeing this contract and I'm stuck with what it says. So you buyer and the seller have agreed upon these terms, and I'm going to close this in accordance with those terms. I might need to clarify a few things by way of addendum, but I can't reach out to the buyer and say, hey, this provision is really going to screw you over. I can't say that. My hands are tied because I don't represent you. So that's another thing that's a little unfortunate when we only serve in that transactional capacity, that I might see something I don't like, but I'm not allowed to say it. And
I don't think people get that. So the only other place that you really see this in the law is in divorce. Sometimes people say, look, we're on the same page. We're gonna share a lawyer, and it doesn't go any better there.
No, not at all.
But I think that's really a lot of times people's only other experience, possibly with a lawyer, and certainly in a situation where they're trying to say, look, we both have the same objective, so we're on the same page. So it seems logical that we could, quote, share a lawyer, but people don't see the downsides to it necessarily up front. So that's something else to consider right at the same time that you're considering how you're going to enter into the transaction.
Right, exactly. And I guess the first thing I would touch on that falls in the purchase agreement that is typically negotiated before it comes to us, or sometimes it's really the discussion is more heavily weighed on the shoulders of the agent that is representing one or both parties, is the deposit. And a lot of people, I feel like a lot of buyers going into the transaction are very excited about acquiring this business, and they want to make sure that they lock it in, and they want to make sure that the seller knows that they're serious. And you certainly want to offer a deposit that is reasonable based upon the purchase price. But I think what a lot of parties don't realize in real estate transactions and in business transactions is that once you remit that deposit to the escrow agent, who may or may not be the closing agent, once you remit that deposit, the only way that deposit can then be released later, even if you have a right to receive it back under the contract, the only way that it can be released later is if the seller also signs off on that release. So you want to be cognizant of that when you're willing to offer some ginormous deposit, because you want to show just how much you love this business and how in you are. Keep that in mind, because unfortunately I've seen some people who have their deposits held up for a good amount of time because the seller is being unreasonable, or the seller realizes that they have the power to hold it up, and they're maybe looking for you to negotiate that release of that deposit a little bit. So just keep that in mind when you're entering into the transaction and remitting that deposit, because oftentimes we don't come into that. We become part of the discussion after that. That's negotiated.
Absolutely. And the other problem is we'll see sometimes that people do expect to have a lawyer. We see this in real estate as well. So they'll put an attorney review addendum on the contract to say, well, my lawyer has 3 or 5 days to look at it. That's great. But if you've already opened your mouth up about the deposit, it's kind of hard for me to come in and be like, oh, I'm whacking that thing down. Everybody's already seen it. So those provisions are great. We have an opportunity to make changes, but those changes are seldom welcome.
And I will also say that particular clause, that the attorney review, we can't make material changes to the terms. That's a big problem. I can come in and clean up a clause that I know this is the goal of the clause, and it's just not written as well as I would like it to be. I can clean it up in that regard, but I can't change material terms. So a lot of times I feel like agents will say, oh, don't worry about it, sign this. We'll include this provision so you can go back and your attorney can revise it later. But what they don't appreciate is I can't make material revisions, meaning I can't revise the amount of the deposit. I can't revise a lot of stuff. Our hands are going to be tied at that point. So it's really important to have your attorney review the contract before you sign it.
And the thing is, if you've got us on board, we know it's coming. We are able to work through the majority of the contract with you before you settle on price. Because I think a lot of times why people do that is those deals come together after hours or on the weekend and they think that you won't be available. Well, I A, may be available, and B, I will have the opportunity to sort that and talk about the deposit and talk about some of those things. So it doesn't, while you're sorting the actual purchase price, that's a range you are comfortable with, that's fine. But some of these other things we could have already addressed if we had a conversation before you are ready to go under contract.
Right, exactly. And likewise, the financing provisions, I oftentimes see in other people's agreements are very general. And you want to make sure that your financing terms are crystal clear, because what can happen to buyers is if you're not specifying the exact terms that you need in order to feel comfortable proceeding with the financing, then you might find yourself in a position where the financing contingency is met and you don't necessarily have a right to terminate the contract, even if you get the financing and it comes back with terms that you're uncomfortable with. So if you have a provision that generally says the buyer, this contract is contingent upon buyer receiving financing, and you get a loan commitment with a outrageous interest rate or a loan term that you're not comfortable with, you're not technically, the financing contingency has been met because you received approval for financing. So you really want to make sure that those terms are very carefully delineated to your comfort level. And a lot of people glaze right over that. Another item that can be a huge problem is the description of assets and the required condition of the assets. So another item that I see in contracts that are not prepared by me include a general description of assets that says something like all of the assets of the business. Well, the problem with that is if you don't have those items specified, and I'm not saying you need to specify every paperclip, but you do need to account for, the number of tables and chairs, especially important equipment items. And I would go as far as even, for really important equipment items, depending on the nature of the business, notating the model number, the year, serial number, the VIN. That stuff is very important because what can happen is, number one, if you have a really general description of the assets, the seller can come and pull those assets out, and you get to the closing and all of a sudden you're buying 2/3 of what you thought you were buying, and you have a fight on your hands. Or in the instance of having a nice piece of equipment, you might think that you're buying this piece of equipment, but lo and behold, the seller substitutes that piece of equipment with another piece of equipment that maybe it's the same kind of equipment, maybe it's even the same model, but if it's 5 or 10 years older, now the value of that piece of equipment is different than what you bargained for. So that's why it's really important to carefully delineate that as well in the asset list. And the other consideration that needs to be made that I feel like is oftentimes overlooked is the condition of the assets. You need to make sure that in the contract that the seller is warranting that the condition will be good working order. If that's not in there, you may contractually find yourself in a position where you have to purchase assets that are now in disrepair. So it's really important to notate those two things. And I feel like a lot of times those are afterthoughts.
Oh, for sure. You know, I oftentimes when I'm trying to beat on people for the asset list, they don't even want to do it. Like it's going to be long. I don't want to count the things. Like even the buyers like, man, and I'm like, how will you know something is missing? How will you know what you didn't get? How will you know that you got a Kia instead of a Bentley? Like you won't know that, and you can't prove it, and you can't just stand there and be mad. And that happens more often than you think as well.
Absolutely.
They got, maybe somebody in the company decided they wanted it, or the brother-in-law wanted it, or they found out they could sell it. And so now they're like, well, I sold that on Craigslist. Well, you were supposed to sell it to me.
Yeah, exactly. And now you have a fight on your hands. So it's really important to.
The other thing that the larger items specifically being listed does is helps us with the lien searches. So you know, if you've got that VIN number sooner, you're going to know, oh, you guys didn't tell me you leased this vehicle, or that there was a loan on this, or that 3 sellers ago is still the owner. We have a tendency to find that out later in the transaction, which causes more anxiety and aggravation and cost and sometimes delay.
Yeah, absolutely. I guess one of the other important provisions that it's going to appear typically in both a stock purchase or in an asset purchase, and that's an indemnification clause, which I kind of touched on earlier. Now, the indemnification clauses can look very different depending on the structure of the transaction and the purchase price. So I'm not going to get into all that, but what I will say is you definitely as a buyer want to make sure that that provision is in there and that it's drafted properly. So not all contracts are created equal, and certainly not all indemnification clauses are created equal. But this clause is basically going to protect you from liability that arises from the seller's operation of the business prior to closing. But if it's not drafted properly, it may not protect you to the extent that you expect. So it's really important that that be in there and that it be drafted properly.
Absolutely.
Something else that I also feel like is sort of an afterthought, but is extremely important. And I see my buyer clients run into some issues with this with some frequency, and that's the familiarization clause. So most of these contracts call for the seller to stay on for some period of time, or an agent of the seller to stay on for some period of time with the buyer to help familiarize them with the business and to make the transition from the seller to the buyer a smooth one. Because, you know, depending on the nature of the business, if there's any kind of disruption in the business, that can be very detrimental, and it can take some time to recover from that. So it's really important to make sure that that familiarization clause is in place, and also that the terms of the familiarization are very clear. What's required of the seller? Phone calls? Do they have to be there in person holding your hand? How many hours a day? What days a week? For what period of time? All of that needs to be very clearly specified. And I would even go as far as recommending that there be some kind of escrow holdback at closing to secure those obligations, because you will, as a buyer, very quickly realize that once the closing occurs and the seller receives their proceeds, they lose a lot of interest in that familiarization obligation. And unfortunately, for some of my clients, I've seen some really bad circumstances where they are not getting the help that they contracted for. It's not, you know, and a lot of times the seller is kind of scratching their head about what's the big deal. Well, I bargained for this. Part of the purchase price I'm paying for this business includes you helping me after closing with this transition. So keep that in mind as well. I feel like a lot of people don't pay a lot of attention to that and can really create some problems after closing for a buyer.
And the flip side of that as well, you may have a seller that if you're buying a business that has not been well run, and you are here to turn it around, you may want to get that seller out of your way. So sometimes sellers will want a familiarization period because they want to get paid, you know, like an employee for a certain period of time. Maybe it's 3 months, maybe it's 6 months. If you have a situation where the staff don't respect that former owner, or the customer base is not satisfied, then you want to be very clear, rip that Band-Aid off and get that person out of the way. So that knife cuts both ways as well.
Right. And to that end also, you know, making sure that going into this and before the contract is signed, that you determine whether or not you're going to be assuming the existing employees. And is that going to be, is the contract going to be contingent upon the assignment of these employment agreements and these employees agreeing to stay on? Because sometimes a huge value or portion of the value of the business is the employees themselves. So if you're buying the business and you have Joe and Frank who run the show, and without Joe and Frank, the business value would plummet, you're going to want to make sure that you have them locked in for a period of time after closing to make sure that you don't lose the value of the business a week later if they decide to walk. So, that's another consideration that needs to be made in the contract, not after it's signed. Also, the restrictive covenants, extremely important. Everyone is aware of, that typically these agreements come with non-compete provisions, but they're not all created equal. You want to make sure not only is the seller not permitted to open up a similar business down the road, but they're also restricted from soliciting your customers and your employees. Again, because those are the value of the business lies in those individuals. So you really want to make sure that that is nice and tight. I mentioned before, the escrow is a really good tool to secure certain post-closing obligations. So for indemnification, familiarization, things like that, a lot of times an escrow holdback can be really attractive for buyers to make sure that there's some clause to these provisions, because sellers are aware of the fact that to enforce provisions, it takes time and money. So if you don't have any kind of escrow holdback, it might be a little more attractive for them to, walk outside of the lines of the contract after the fact, after they get their money. The other really important item that I feel like a lot of people glaze over is the assignment and assumption of equipment leases and commercial real estate leases. And this is really important because even though you might have a clause in the contract that talks about the contract being contingent upon the assignment of the lease, if you haven't already reviewed that lease with your attorney, you may not like how that lease looks. You may not like the terms of the lease. You want to make sure that the assignment and assumption is subject to terms and conditions agreeable to you as the buyer. The other issue that I've seen some clients run into is they don't take a look at the lease on the front end. They sign a contract that has one of those vanilla clauses that just says that it's contingent upon the landlord's assignment of the lease to the buyer. And the buyer gets their hands on the lease, and all of a sudden, the lease has a term that's expiring in 11 months. Well, if a large part of the value of the business is based upon the operation from a particular location, or the operation of particular pieces of equipment, if you only have a handful of months or even years left to operate in that particular location, that can be very detrimental to the value of the business, because you can't assume that the landlord's going to automatically renew that lease with you. And you can't assume that they're going to renew it at the same lease rate. So that's a really, really important provision to make sure is drafted properly.
And flip side of that, and just devil's advocate today, flip side of that as well is if you think you want to fold the operations into your existing company, if you're buying a competitor, or if you're buying something that you think could do better in another location, you want to make sure that you're not strangled by some super long lease that you can get out sooner if you need to.
Yes.
All of this goes both ways, and it just depends which side of, so there's not like, this is what you want to push for. It depends on the circumstances. It depends if, on each individual business and on the nature of the buyer.
Yeah, exactly. In certain instances, if you're buying a business, it might be subject to a franchise. In which case that's a whole nother level of negotiation, and you need to make sure that that contingency is properly crafted into the agreement. And
that you tell the franchisor.
Yeah, that you tell the franchisor.
Some sellers that you've had that have said, "Oh, we're just not going to tell them."
Yeah. No big deal. Or we'll tell them after. We'll notify them after the fact. No, you can't do that. These franchise agreements are not going to permit you to just assign the assets to anyone. And in fact, they hold an indirect lien interest on the assets of the business. So just keep that in mind. Also, when it comes to a franchise, you might want to negotiate on the front end, because a lot of parties run into this on the back end and they're pissed, is the payment of the transfer fee. So typically when there's a transfer of a business within a franchise, there's a transfer fee, and there's certain fees you have to pay to the franchisor just to review and consider your request. And a lot of times that's not negotiated in the contract, and the parties are pointing at one another like, well, I'm not paying that. Well, I'm not paying that. And the contract is silent to it. So just make sure you also consider that as well. The general representations and warranties, which we can get into in another webinar, are extremely important to be included in the contract regarding title, regarding pending legal actions. That's a really important one that I'm going to touch on in a second, because even if you have, say you're buying the assets and you're not assuming the liabilities of the seller, if there is a pending action or claim or potential claim, if the seller transfers their assets while that is pending, there's still a chance that the third-party plaintiff who's making that claim against the seller could try to attach that claim to the assets that are being transferred. I'm not suggesting that they will be successful, and it may not, from a legal standpoint, become the buyer's liability if we're talking about an asset purchase, but it practically will become the buyer's problem. And you might fall into a situation where the legal, the third-party plaintiff is filing a claim against the assets, and you have to pay an attorney to remove the claim. And who knows how long that's going to take. And many times you have a buyer who buys a business and after a couple of years decides they want to sell the business for whatever reason. Now your business is not marketable because you have this claim against your assets that has nothing to do with you, that had to do with some action or claim that arose from the seller's operation of the business. So for that reason, you really want to make sure that these reps and warranties are included in the contract, because if they're not, then you won't have a way to put your hand up if and when you do discover a claim after you fall under contract, but before the transaction closes. And then allocation of purchase price. When it comes to an asset purchase, I know that Joanne and Marina will go into that, but you definitely want to make sure that you're kind of agreeing on the front end what that allocation will look like, or at least that you have a provision calling for the parties to agree to that before closing. Fighting about that after closing is not going to be fun, and there are tax implications to how that allocation falls. So
absolutely. And that's something that really the buyer and the seller are at complete odds on the asset allocation. So if you don't agree to that before closing, now you can end up in a situation where everybody's filing different tax returns. That gets ugly. That's part two. Come back for that disaster. But that the importance of that and some other of the tax elections that need to be addressed, like 1377, for example, need to be in the contract. If you are going to change ownership in the middle of a year and you want to, if you're buying a stock, if you're doing a stock purchase, that's something that needs to be discussed. So I don't want to sidetrack us on that, but we'll hit that in the tax piece as well.
Yeah, that'll be fun.
Stay tuned.
So after you go under contract, and the next step typically is going to be the due diligence period, whether it's a stock purchase or an asset purchase. And this period is extremely important. I highly recommend using an attorney and an accountant to review the financials and the corporate documents of the seller, if it's an asset purchase, or of the company for which the stock or membership interest is being transferred, if it's a stock sale. So you need to take a close look at all of these things just to determine, number one, the financial health of the business, to make sure that it truly is what it's been represented to be, which is going to be what the purchase price is based upon. You also want to make sure, especially if it's a stock purchase, that there aren't any accounting errors that maybe might come up from review of the financials. So whenever you have an accountant that comes in and reviews the tax returns, they might see something that will raise a red flag, which you really need to strongly consider before purchasing the stock, because that's going to become your problem. If there's an audit down the line, that's going to become a problem for you, and that could ultimately be money out of your pocket if the company has an assessment. So you need to take a very close look at that. On the legal side of things, you definitely need to take a close look at all of the contracts for the business, lease agreements, employment agreements, things like that, so that you really know what you're stepping into. Also, most importantly, for both of these structures, is to look at the chain of title to the assets to make sure that in fact that the assets that are being sold are actually owned by the seller and were properly acquired by the seller, and making sure that the stock that is being sold was properly acquired by the buyer or seller. And this goes back to what we were saying at the beginning, that, you know, people come into possession of assets or stock and they may think that they've done so properly, but they have not. And that means that they don't necessarily have the right to sell you these items. But once you've given them the consideration for it, chasing down the corrective documents necessary to make sure that you have valid title to those items is going to be difficult. So it's really important. We, as a closing agent, the closing agent's going to review these items to a certain extent anyways, to make sure that clear title is passing. But it's still really important during the due diligence process to make sure that everything is in order, because once you are outside of the due diligence process, it's going to be a little bit harder to pump the brakes, and it can really hold up the transaction and make things messier. So it's really a good idea to take a close magnifying glass to all of these items while you're under the hood. And also really important too, if you're buying the assets, take a look at the physical assets. I would not rely on pictures. I have, again, I've seen clients as buyers go in and not actually verify the exact vehicles that they're purchasing. So I've had a client who was buying a fleet of vehicles for a delivery business, and the seller happened to have another delivery business in another county. And what happened was they closed on the business. The buyer had seen the vehicles used operating the route that he purchased. And then all of a sudden, those vehicles were pulled out, and some other older, you know, vehicles that were basically in disrepair were substituted. And it's because he didn't go through and actually physically identify each vehicle asset to make sure he knew exactly what he was purchasing. And it's very unfortunate, but that can happen if you don't take a close look during due diligence and make sure you know exactly what you're getting. Any horror stories there, Joanne?
You know, how much time are you going to give me? Because it's, you know, that you can repeat, you can rinse and repeat, because especially the more assets of the business, the more people are like, or the other thing I see them want to do is print the asset schedule from the tax return, which I promise you nobody, including the accountant, has looked at in 10 years. Like, that is, I guess, better than nothing, but that to me is not, that's not a real asset list. It should be, but very seldom in practice is it actually accurate. Lots of times that business schedule of depreciable assets maybe doesn't include computers or cell phones or some expensive but smaller equipment that people just don't put on the depreciation schedule, or there's a computer from 1997 still on there. They have no idea they're paying, like, you know, personal property taxes on it. The accountants have a heart attack because nobody wants to look at that list. But it's definitely one of the most overlooked parts of the tax return, and definitely is not something I would encourage you to use as an exhibit to the contract to say, here's what I'm buying.
Yeah,
it should be the perfect place to go, but it's not.
Exactly. And you know, the next step also in a transaction like this is going to be a judgment and lien search, which the closing attorney is going to run. And this is to make sure to clear title, that there are no liens or judgments that could encumber the assets that are being acquired, or that could encumber the stock that is being acquired. But what I will say is, you know, in addition to that, you want to make sure that you have a good attorney doing this for you, because oftentimes, I don't know, Joanne, how often you see this, but oftentimes I feel like, especially in a stock sale, the attorney who is completing the closing may be obviously geared at clearing title to the stock, but a consideration that also needs to be made is whether or not there is clear title to the assets of the company, because you're basically indirectly purchasing the assets of that company when you're purchasing the stock of that company. And you know, the contract should confirm what assets of the company are encumbered and which are not. So typically, if you're buying stock, you might have a schedule to the stock purchase agreement that lists the assets of the company as well. And it will also confirm, you know, that the commercial real estate is subject to X mortgage with Chase at this principal amount. So it should say that. But people would be shocked how often there may be additional liens and encumbrances against the assets of a company that they were completely unaware of, because maybe one of the other shareholders or members took out a mortgage on something else or put a lien on something else. So you really want to make sure, even if you're purchasing the stock, you're not just focusing on clearing title to the stock, but you also want to make sure that your attorney is focusing on the encumbrances of the assets of the business itself. And I feel like that is oftentimes overlooked. And that also goes into some of the reps and warranties that we'll get into in more detail on a later date. An additional search that I also recommend that a lot of closing agents may not include, because again, if you're purchasing assets from a legal standpoint, you're not technically supposed to be assuming the liabilities of the seller. However, you will inherit some of the headache that comes if there is an actual action that's pending at the time the closing takes place or while the contract is in place, just because the third-party plaintiff can try to make a claim against those assets. They may not be successful, but it will still be your problem. So for that reason, I also recommend that there be a search of pending actions in the public record in which the business is located, in which the seller, you know, where the business is conducted even. So you want to add that search on in addition to the judgment and lien search. Even though it's not technically required to clear title, I recommend it because it can still cause problems for a buyer down the road.
Absolutely.
So, and then one other item that's extremely important that a lot of people are unaware of, and that even some practitioners are unaware of, which is a little spooky, is the Florida Department of Revenue can essentially lien business assets that are acquired from a seller after the fact. So the tax liability that is asserted by the state can follow these assets unless you obtain what is referred to as a certificate of compliance. So this is a certificate that's issued by the Department of Revenue. It's a very simple process. It takes 5 to 7 days to get back, but it basically confirms that there's no action or outstanding amounts due from the seller to the Department of Revenue. And this is sort of a way for a buyer to stop the department from coming after their assets in the event that an assessment is later made. So you might have a seller who is doing everything they believe according to the book and according to the regulations, but their accountant has screwed something up. If the Department of Revenue discovers this after the fact, they can technically come against the assets of not only the seller, but of a buyer who acquired assets of that seller. So you really want to make sure that you obtain that certificate of compliance. It's very quick and easy, and it will protect you down the road in the event that there is a, you know, an audit or an assessment by the department. And I believe, one other thing I just wanted to mention, in general, there's going to be certain prorations at closing for things like tangible property tax, for rental, for employment compensation, and things like that. That is typically covered in the contract, but sometimes it's not, and you want to make sure that those items are properly accounted for. And just going back to the importance of having an attorney to actually handle the closing, whether or not that attorney happens to represent you or not. When you get to the closing table, one of the important roles that the attorney plays is making sure that all of the documents come in that are supposed to be delivered in accordance with the contract, and all of the funds are dispersed to who they need to go to, whether it's a lien holder, whether it's the agent. There's going to be a number of parties that have to be paid from the closing proceeds, and having an attorney in place to make sure all of that is done properly is very important. So just reiterating why, regardless of which attorney it is, just make sure there is an attorney that's closing this transaction. And that's all I have for today, believe it or not.
And those are all spectacular points. I can't say enough the importance of two things. Number one, a conversation with the lawyer before you sign the contract. What people love to do, whether it's business or real estate, is sign it and then bring it to you. When that happens, we're like Katie Couric. We give you the news. Like, you tie my hands. And I don't want to say it's not worth it for us to read it at that point. It's just so much less helpful. And you pay to read the same document. So it doesn't save you any money to do it later. I think what some people feel is pressure, like, well, what if they don't accept the offer? Then I paid you to read it. But oftentimes those offers are very similar, particularly if you're working with a business broker or an agent. You're submitting the same form. So there's a benefit to having familiarity with those provisions that we've discussed before you've even identified the perfect business. This will allow you to move through that offer process much more quickly and efficiently and smoothly with peace of mind, knowing that you're not just like peeking through your fingers to hope there's not an exploding bomb on the other side. The second piece is the importance of having a team. If you are buying a business, you need a lawyer and you need an accountant anyways. So finding them 3 months later when you're behind on sales tax and your QuickBooks is a disaster is not helpful. Get that team in place ahead of time, and you're going to need it. One thing that we see is a lot of times today we're talking about from the buyer's perspective, but when you go to sell, you don't want your first experience with your lawyer and your accountant to be the sale of the business, which is a huge part of your a huge transaction in your life. And so you want this person hopefully to be somebody that's on a team that's going to help you grow that business, help you run it better, help you run it more efficiently, maybe help you scale it or pass it down to the next generation in your family, whatever your objectives are. It sounds insane, but that really ought to be discussed on the front end. It's not relevant to the contract, but it certainly is relevant to how you're going to structure this. Maybe it's relevant to how you're going to pay for it. Maybe it's relevant to how much you're willing to pay. So the more we can sit with you and have a peek into your goals and objectives, the better we are able to service even that transaction. My favorite line in the whole world, and I will perpetually give her credit to Whitney Harper, is don't make me look in a dark room with a flashlight. And the more you limit the scope of your lawyer's representation, or you don't get a lawyer and an accountant, you're making the lawyer do everything on the front end and you don't have any input from the accountant, you shrink the size of the light coming out of the flashlight. So we can help you better if there's stadium lights on and we can see everything. And having that team in place is so critical that you may as well do it early because you'll get more benefit from it. It's not really a cost savings to avoid it. And not every lawyer is familiar with tax and accounting like our firm is uniquely positioned to do. However, there's still plenty of good business lawyers who you need to put on a team with an accountant. So I just can't say it enough. And it's probably the thing, people are trying to do this on a shoestring or trying to keep the cost down. You might avoid, we had one guy who was trying to buy a mobility cart business years ago. And the client ended up mad at me because as we got into the due diligence and did the searches, we found that there were like 3 patent infringement lawsuits that were passed and pending. And so, he had spent some money and he was like, now I have no business. And I was like, you avoided wasting $500,000. You should send me flowers. I don't ever want these transactions not to come to fruition, but I would rather disappoint you before you've spent your money and say, hey, look, there's this problem that you weren't aware of and the seller didn't disclose. This is a situation. That doesn't happen often, but I've done this 15 years and it's happened to me more than once. So it's not a blue moon that it happens either. So those are just considerations from our vault of war stories, the things that we see. The nice thing about working with a professional is this is not our first transaction. So there are things here that will not surprise us. And when Jackie mentioned franchise agreements, lots of times when people call me and they're like, hey, I want you to read this. I want you to do a cursory review of my franchise agreement. Cursory review of your 100-page agreement that I already know what it says. I don't, I can read it, but it's not cursory. You have to read every word. Because if I skip the words that cause the problems, you'll be mad at me. So I still have to read everything. But the problem is, they'll say, oh, I don't want to spend that much money. Okay, well, let me tell you, here's what you're going to find. And they're like, wow, how did you know that? Just because I've read so many. You've looked at 2 or 3, and I've looked at 2 or 3 a month for 15 years. So it's just repetition and opportunities to see things done differently. That's, and that's what you're picking up. And the value to that sometimes can't have a number associated with it. It sometimes pays dividends hugely, and people see that in their transaction when a big issue or cost or headache was avoided. So anyway, that is, I guess, all we'll have for today. We would love to hear more from you in terms of what topics you'd like to hear about. We cover a variety of real estate, corporate, and tax subjects, and oftentimes have guests in on other areas of expertise outside of ours. So if you've got something that you'd like to hear about, please email us and let us know. You can always catch our recordings on our Facebook pages for Koontz Associates and Koontz Parkin. You can like us and follow us there to see what the upcoming topics will be. We do try to provide our schedule a month in advance. You also can catch these recordings on our YouTube page and on our websites, KoontzAssociates.com and KoontzParkin.com. We will be with you next week on Tuesday, as always. And if you have any questions in the meantime, we're happy to help. Thanks so much, guys. Have a great week.